Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. As many of you know, President Obama has issued an executive order regarding immigration reform, and I have other videos on the subject, but what I'd like to concentrate on this time is, in this particular video, is not the DAPA or the expanded DACA or the employment-based increase and so forth in moving forward, but rather the basically what can be referred to as the prosecutorial discretion memo, which was put out by the Secretary of Department of Homeland Security, Jed Johnson. And this particular memo, while technically it's not law, it enforces the policies, the new policies pursuant to President Obama's executive action. And the memo is quite sweeping, okay? Just so you know, it was sent to the acting director of the U.S. Immigration and Customs Enforcement. It was sent to the commissioner of the U.S. Customs and Border Protection. It was sent to the director of U.S. Citizenship and Immigration Services. And it was sent to the acting assistant secretary for policy. And it specifically said that this is to be the policy which is to go forward regarding the apprehension, detention, and removal of undocumented immigrants. So there's lots of good information in this, and it can be used in order to try to keep you or your friends or your family out of detention, in order to try to get you out of detention, and in order to try to stop them from taking you into detention in the first place. So the particular memo also makes clear that prior memos on priority enforcement are essentially no longer valid, that it is this one that controls, and that this one is the one that needs to be referred to. So let me just tell you, and this is just going briefly over what the memo is, but it gives you an idea of the breadth of the scope and the breadth of the changes and the policies that are going to go forward. Now, also keep in mind that, obviously if and when President Obama is no longer president, these policies may change. But as it stands right now, these are the policies. And even though, the expanded DACA you can't file for another 90 days, give or take, and the new DAPA is going to take another 6 months, the policies regarding enforcement have started from the time that this memo was sent, which is already, okay, it's today. So let me preface it by saying that when they refer in the memo to civil immigration enforcement priorities, they're talking about, basically, you look at a typical ICE official, and that ICE official is looking at a particular person who's here illegally. Should that ICE official put that person in removal proceedings? Should that ICE official try to deport that particular individual? And how does that ICE decide whether or not to go forward with basically executing what's necessary to get this person into removal proceedings and to try to deport them from the United States? Well, the new memo has 3 different priorities, okay? Now, these 3 different priorities aren't just 3 equal priorities, and, whichever one you happen to fall under, that's the one that is applicable to whether you get deported or not. It is priorities in order of enforcement. So, for example, if you fall under priority 1, you have the highest chance of being put into removal proceedings and deported. If you fall into priority 2, then it's a mid-level chance of being put into removal proceedings and or deported. And of course, priority 3 is the lowest level, but it's still a priority as to whether or not to put you in to removal proceedings. And then, of course, if you don't fall under priority 1, priority 2, or priority 3, while there is language in the memo that still gives the right for the officer to try to deport you, if you're not under any of the priorities, there really realistically is a relatively small chance you're going to be put into removal proceedings at this point. So let me describe in a bit more detail what the priorities are. Now, let's start with priority 1. Okay, again, this is the biggest priority with the highest chance of being put into removal proceedings. Now, priority 1, a great deal of it deals with whether or not you have any criminal history, but let me just list you what it is. So, people who are here illegally and who fall under any of these categories, there are 5 different categories under priority 1. Okay, they are, first are basically people who are in or suspected of terrorism or espionage, or are otherwise they pose a danger to national security. Now, I suspect that pretty much everybody watching this video and most people on the streets today who are here illegally do not fall under this category. But if you do, then you're a priority 1 target. So the next one is people who are apprehended at the border or ports of entry while attempting to unlawfully enter the United States. So, in this particular, you don't have to have committed any crimes. You don't have to even have been here illegally a single day. But if you try to enter the United States illegally or unlawfully, and of course that includes, fake passport, fake, or someone else's passport, fake green card, or someone else's green card, so forth, then you are a priority 1, and it is likely that you will be expeditedly removed because you are a priority 1 target. Just policy-wise, obviously, if people were to come into the United States illegally and it didn't maintain a high priority, that would almost obligate immigration to allow them to come in because they couldn't deport them or send them away, and that would essentially increase the number of people who would just try to get here in the U.S. illegally. So that would be the second level. Now, the second item under priority 1. Now, here is the first one we're going to get to, which is the third item under priority 1, which basically where a lot of people will fall under. Okay, those are people who are convicted of an offense. Okay, which is the following one. They were an active participation in a criminal street gang. Okay, now there's some issues here. Like, for example, someone can be in a gang, but that doesn't fall under this particular category. It's where an element of the offense was active participation in a criminal street gang. So that does limit it somewhat, because as of the present time, for example, you go to see it at Juarez, and if they see a tattoo on your neck that they know a lot of gang members would get, they're going to say, nope, you're not admissible, and they're not going to let you in. So there's obviously been a lot of playback on that and unfairness in that someone may have, been in a gang 20 years ago, and now they can't get into the U.S. because of it, and they have no convictions because of it. So essentially, because of that, this particular item does make sure that there has to be a conviction where an element of the crime deals with being in the gang, or another part of this element is that the person here in the United States who's illegal is not younger than 16 years of age, and who intentionally participated in an organized criminal gang to further the illegal activity of the gang. So whereas before I was saying there has to be an actual element of the crime that they were convicted under, if of course they do find that you were over 16 and participated to further illegal activity, then that does broaden the particular item regarding being in a gang, and that is a priority one enforcement. So there are ways in which to argue that you are not, if you were in a gang, that you're not under this element. But of course, it needs to be properly argued and submitted. Now, the next item, again dealing with crimes, is if you're here illegally and you're convicted of an offense which is classified as a felony, okay, um, of which the essential element was basically not the alien's immigration status. So let me read it to you exactly what it is here. Let me tell you, it's aliens convicted of an offense classified as a felony in the convicting jurisdiction other than a state or local offense for which an essential element was the alien's immigration status. So at this point here, you have to look at what it was that you might have been convicted of. You have to determine whether it's a felony or a misdemeanor. You have to determine whether your immigration status has something to do with it, and then you could fall under this one. Now, these particular crimes may or may not apply to you. It may or may not be heavily used, but again, there are some there is some leeway in which to argue that you are or are not under this. And then probably this is the last one that is under priority one, stating that basically people who have been convicted as an aggravated felony at the time of the conviction. So that is very important here, that they're saying at the time of the conviction, because you might have been convicted of something, 15, 20 years ago, and then the law changed in 1996, which turned that conviction into an aggravated felony, after you committed the crime. So, while in immigration court, there's, Supreme Court cases, Sincere, and other cases that, essentially said that people who committed crimes before IRA made it an aggravated felony or forms of relief. But it's nice to see that in the actual item in the memo, that they know that what you might have been convicted of at the time you were convicted is not an aggravated felony at that time. Because of that, you might not fall under this particular category. So essentially what you're going to want to do as I go through this, definitely get a good immigration attorney to fight for you here. But first thing you want to do is try to get out of priority one. Okay, try to have the attorney argue you are not a priority one target. Maybe you're priority two, maybe you're priority three, but the key here is to do what you can to get out of priority one. And so essentially, in priority one, those are the essential items. Now let's go to priority two. Okay, this is again a mid-level or the second priority, which again may or may not apply to you, your family, or friends. But let me just tell you again, when that officer is looking at you or some other person and deciding whether or not to begin and start proceedings against them, first they look at what we just went over, priority one, of which, if they determine the person's under priority one, you can pretty much be assured they're going to put you in removal proceedings. But then they're now going to go to priority two, and they have more discretion under priority two not to put you in removal proceedings. Okay, so that's why you want to try to get into priority two if you can, or argue that you are. So what are the elements of priority two? What are the categories? So there's 4 of them. So just so you know, they title priority two as misdemeanors and new immigration violators. Okay, so what does that mean? So the first one is when you have been convicted of 3 or more misdemeanor offenses other than minor traffic offenses or state or local offenses for which an essential element was the alien's or your immigration status, provided that the offenses arise out of 3 separate incidents. So again, if you look at this particular one carefully, I mean, obviously it doesn't include traffic offenses, but it's not just any misdemeanor offenses. Okay, I mean, let's just say, for example, you have a burglary and a theft and whatever else you might have, but it has nothing to do with your immigration status. Okay, that there are no elements in the crime itself that if somebody who had been born here, 50 years ago did the crime, they'd still be convicted of it regardless. So for this particular item, you have to be it has to be a misdemeanor, and it has to some element of the crime needs to be dealing with your immigration status. So I can see where a lot of people who just have misdemeanors might confuse that they're under priority two because of that under this particular item, when in fact they're not. So what's the next one? The next particular one is when you're convicted of a significant misdemeanor. Now, how do they define significant misdemeanor in this memo? Where, fortunately or unfortunately, however you want to look at it, they do have some definition here. If it is a misdemeanor for domestic violence, sexual abuse or exploitation, burglary, unlawful possession or use of a firearm, drug distribution or trafficking. Notice it doesn't say drug possession, okay, which is good if you just have a possession crime. Um, Driving under the influence, or, and this is the big one, if it's not listed in what I just told you, then you had to have a sentence where you actually served 90 days or more. That does not mean that you got, for example, a 6-month suspended sentence and you served 3 days because you did, a year community service. It means you have to have served in jail 90 days or more. Okay, so that's how it defines significant misdemeanor. And note that's not 3 significant misdemeanors, it's just 1 falling under this category. Okay, now just so you know, if you fall under this category, again, you can go to a criminal immigration attorney who knows what they're doing, and they can try to file to reduce or vacate that particular crime so that as a significant misdemeanor, and then of course you wouldn't be under this particular section. Now, what about the next element of priority 2? Well, those are people who are apprehended anywhere in the United States after unlawfully entering or re-entering. Okay, so you unlawfully enter or you come back and unlawfully the U.S., who cannot establish that they have been physically present in the U.S. since January 1st, 2014. So what is this saying? Okay, well, basically, it's just saying that if you don't have any crimes, okay, if you don't fall under the other particular categories, but let's just say you entered the United States unlawfully 2 months ago. Okay, you're basically going to fall under this particular section. They want to give priority to people who entered prior to January 1st, 2014. Now, because it's not even 2015 yet, this is a pretty good item in that most people generally will have entered before January 1st, 2014. So this should be one that most people have an easy time getting around, except, as time goes on, of course, it's going to be harder because, January 1st, 2014 isn't going to change. But as of now, if you can prove that you entered, whether it's lawfully or unlawfully, prior to January 1st, 2014, and you don't fall under any other categories, then you're not under priority 2, okay, which is a good thing. I mean, it's basically saying you could have entered here illegally 5 years ago and, not fall under any of the other categories, and you're not a priority for them, even though you entered illegally, even though you've been here illegally for all this time. Okay, that is what President Obama wanted, to not target people who have been here for a while and who are not a priority. Okay, and then the last one is under priority 2 is where in the judgment of the person who's going to decide whether to deport you or not or put you into removal proceedings, has determined that you have abused the visa or the visa waiver programs. Well, this is wide open. I mean, how do they determine whether you've abused it or not? I mean, let's say you came here on an H-1B and you know you let it expire and you didn't file for a change of status or extend it. Does that mean you've abused the visa program? Let's say that you came here and the company went out of business and you didn't leave. Have you abused it? Let's say you came here on an F1 and your parents' business home burnt to the ground, which is the actual case I have, and they couldn't send you money for school anymore, so you stopped going to school. Does that mean you've abused your visa? So there's a lot of leeway and ambiguity. It's ambiguous as to whether or not this actually applies or not. So this will these are items are what's under priority 2. Okay, now priority 3, which again is the least priority, although again if you don't fall under priority 1, 2, or 3, then you are not a priority to be deported, period. It doesn't mean they can't still do it, and there's stuff in the memo that gives them the authority, but for all intents purposes, if you're not under priority 1, 2, or 3, you're looking pretty good, okay, as far as being able to apply for something or be able to get some kind of prosecutorial discretion to be able to go forward. So priority 3 are those who have been issued a final order of removal on or after January 1st, 2014. Okay, so basically those who don't fall in to priority 1 or priority 2, they do represent the third and lowest priority for apprehension and removal. And the only element of item priority 3 here is that they have been issued a final order of removal on or after January 1st, 2014. So there's lots of play here, as you can see. I mean, for example, what if you've been issued a removal order prior to January 1st, prior to January 1st, 2014? Well, essentially what they're saying is that, let's say you're not under priority 1, you're not under priority 2, and you have a final removal order as of, maybe 2013 or 2012. That means you're not in the priority to be deported, okay, or for them to go after you if you happen to, either come here illegally, re-enter illegally again, or just stay here and not leave. So essentially, if you have a removal order prior to January 1st, 2014, then it's looking pretty good for you to be able to fight to stay here. Obviously, if you do have a removal order after January 1st, 2014, and you decide that you're not going to, that you're not under any of the other priorities, then in that case, priority 3, which has the lowest priority, you still have a good chance of arguing to not be deported. Okay, so those are the priorities. There's other items with this memo which I'll get into in other videos, but for now I've elaborated on the different priorities and hopefully made it a bit clearer for you. If you liked the video, click like. Otherwise, call my office or schedule for a free consultation so I can determine and help you in regards to seeing if you're under any of these can be done about it and about applying for the relief per the executive order. Okay, more on the coming videos.